All right. First thing, cell phones. Please mute them before we start our meeting. Time being just after 4 o'clock, I'll call the meeting to order. Gary, would you please do a roll call for us?
Healy. Here. Heine.
Here.
Kettering.
Here.
Los.
Here.
Nelson.
Here.
Welsh.
Here.
Catholic.
Here.
Burns.
Here.
Hornstra.
Here.
And we have a quorum present. Next item, does any member have a reason to abstain for a financial or a non-financial conflict of interest?
I do not. No conflict.
Loest, none.
Hornsby, none.
Heine, none.
Nelson, none. Catholic, none.
Welch, none.
Thank you. Approval of the agenda. Are there any additions? Entertain a motion to approve.
So moved. Second.
I have a motion and a second to approve as presented. Any discussion? All in favor say aye.
Aye.
All opposed, nay. Motion carries. Agenda is approved. And we need to approve the minutes from our last meeting, which was February 28th or 9th? March 21st. Oh, crap. You can tell where my timeline is. So, all right. Any changes to the minutes? Entertain a motion to approve.
So moved. Second.
I have a motion and a second to approve the minutes from the previous meeting. I won't make that mistake again. I'll just say previous meeting. All in favor say aye.
Aye.
Aye. All opposed, nay. Motion carries. The minutes are approved. All right, at this time, we will take public comment. And I see there's a lot of folks here, so I do request that you keep your comments as concise as possible. I know we've heard a lot of comments over our last 8 or 9 or 10 meetings. We've met quite a bit, and a lot of stuff has been shared. So if you do your best not to repeat some of the stuff you've already said, but to try and focus on something new. With that, when you come to the microphone, please state your name, and again, try to keep it to 3 minutes. The floor is open.
My name is Lori Slutton, and as you all know, our family farm is in the bullseye of the Spring Valley proposed wind farm, and you know that we don't want them in our county. I'm a very good debater. If I engage in a debate, I usually win, but I am not here for some personal debate winning thing, and I'm not here to make your job harder. I am like over 200 people that came to our meeting on Tuesday night. I have questions about how the wind farms are going to affect our agriculture industry. So today I'm here as an agriculture producer and a crop farmer in Yankton and Turner County, and I'm asking you to carefully listen to what I have to say today. I have a torn shoulder from catching ewes. I have damaged knees from kneeling on the barn floor for hundreds of hours over the years to help sheep. In 2008, we had a strain of Vibrio go through our flock, and I've laid on the frozen ground with my favorite doe as she bled to death because there wasn't anything we could do for her. I've given mouth-to-mouth resuscitation to sheep. I know the pain of selling off a 500-head flock of ewes after we spent 20 years building up our genetics. And my blood, sweat, and tears are literally in this ground. I also know the joy of being present for thousands of lambs' birth, and I know the joy of watching them play King of the Hill on the manure pile, and the joy of walking to the barn in 0 degrees weather at 2 a.m. and seeing the moonlight glistening in the snow in the silent night, and stepping out to hear the birds. Livestock producers like me want our way of life protected from the big money wind industry that only cares about the fact that there is wind on Turkey Ridge, and they know how to make money from it. Putting wind farms close proximity to farms is a risky new experiment. I have read anecdotal reports of chicken eggs with no shells, dairy cows that stop producing, cattle that won't settle with calves, and livestock that drop dead from wind farms when the electricity runs to the ground. I've been reading reports on the wind turbine syndrome in livestock in Texas, Japan, France, and Portugal. This is a copy of a very detailed study. It's in my bag. It's about that thick. That was published. The copy is a very detailed study of acquired flexural deformation of the distal joints in foals. And I was the 4-H hippology coach, so I'll translate. Severely deformed feet and ankles in the legs of horses. The deformities were not genetic. They were caused by the vibrations of newly installed wind farms near the livestock producers. There's a link to the study in the handout that someone else will give you. As wind farms have recently been placed near producers in Texas, the same disability is being seen in the U.S. now. In Japan, cattle near the wind farms had swollen joints that disabled them. When I am looking for a new genetics for my flock or judging an animal in the ring, the most important thing to evaluate is its legs and its feet, the animal's foundation. These deformities cause hooves to rotate backwards. My son is a very good farrier. These deformities cannot be fixed by a farrier. The legs are unsound. Cattle breeders cannot put 1,500 pounds on calves with unsound legs, and breeders cannot use their stock or sell stock with unsound legs. These deformities could cause many producers to sell off their flocks and herds, just as we did when we retired 5 years ago. The decision made here in this county commission and at the county commission could very well hold the balance of the health and even the existence of the food-producing multi-generational livestock production industry in our county. My kids are supposed to inherit land in Yankton and Turner counties. They want to come home and farm. But if we allow this experiment, there might not be anything for them to come home to. We can't be like ostriches and stick our heads in the sand, just hope it'll all turn out right, because we don't yet have proof of large-scale issues. If we let the big money, out-of-state foreign businesses build a huge wind farm and cover our country with 100 towers, we could destroy the livestock industry here. Once the towers are installed, we can't just take them out in 5 years if we have serious problems.
So-
I don't know how close those towers have to be, and I need you to hear me. And nobody in this room does either. But why don't we have the information? The main reason is that this industry is new and it's moving fast. Secondly, there's little regulation on this industry. Many Americans are willing to stick their head in the sand for $500,000 to $10,000 a year and let the big business and big government do what they want in their backyards. Up till now, these wind farms have been placed in ranch country, away from people. But if they're placed here, our livestock is not going to be able to move away like they can on a 20,000-acre ranch. They're going to be in their pens and they're going to be close to them. Big money buys research, and big money buys research results. Big money decides what is sponsored in the news media, and big money decides how the story is spun. And big money decides what information is pasted on the first page of internet search and which one is buried on page 521. Today, it's hard to believe that 70 years ago, it was standard procedure in the United States to give a pregnant woman an x-ray every month of her pregnancy. And now we know better, and we don't x-ray women and we protect babies from them. I did not consent to let big money wind industry experiment on our lives and our livestock in our country, in our county. And I know that your job is supposed to be really straightforward, but I don't think it really is. I am asking you to listen to us and not stick your head in the sand. If a seismograph cannot function properly unless it's 10 miles away, was that accurate? 10 miles? Then I don't think we can expect our livestock or our people to function properly in they're 10 miles until they're 10 miles away from the wind tower. I'm asking for all of you to draft a statement, or some of you, to draft a statement to the commissioners recommending that we place a 20-year ban on the wind farms in Yankton County, so we have the actual data. And I'm asking you to put those setbacks back to 10 miles until we know what's going on.
So you're at 6 minutes right now.
Yep, we have no obligation to open our doors to big money, foreign companies to move into our backyard in order to experiment on us and make money off of questionable government entities. I am a farmer. I am a natural risk taker. But in this case, somebody that I've never met is asking or demanding that I take a risk with my family and my flocks, and they're going to harvest all the profit. Thank you for listening to us. And the study is in here, and it is a very scientific study.
Thank you. Next person, please.
Yes, first off, ditto. That's a hard one to follow. I'm Sarah Christensen. My husband is Leland. We're here. We're landowners in Yankton County. I guess I'm not a public speaker, so I'm gonna make it real fast and short for you. Back in December of 2019, we joined in with a lease with the wind farms. I have regretted it ever since. The information wasn't as available then as it is now. Of course, there's been more research going on since then. We followed it. We're looking into attorneys to try and get us out of the lease. And I guess I'm just concerned about the footprint that it's gonna leave for our kids down the line. The land I'm talking about has been in my husband's family for over 130 years. So now that we even talked to an attorney beforehand, and I guess I kind of feel we were maybe led astray. He said the contract was good and that. And I guess it was good for somebody, but not feeling like it was good for us right now. So I guess we're against the wind farms. Thank you.
Thank you.
Ma'am, you did a great job.
Can I hand these out?
Sure.
Sure.
Absolutely.
An open letter that I don't think I have enough, but that some writer that can do a whole lot better job than me wrote to, an open letter to President Biden.
I'll get it out to everybody.
Thank you.
My name is Terry Clark. I'm sure I'm familiar by now. I keep thinking that I've said everything I have to say about this, but every time I go look into it, I just am astounded. I end up with more and more concerns. Last night, it recently came up about these deformities in the horses I heard about, and got to wondering about other livestock and animals. And we've talked about birds and wildlife, but we haven't really talked about the animals, the livestock and domestic animals. So I just did a quick search on the internet, and even though this is a little bit hard to find, as Lori mentioned, just a 2-hour search found that there have been reports from all over the world, Canada, Australia, Japan, France, Germany, Poland, Taiwan, Portugal, Belgium, United States. Just some of them I found in a brief, 2-hour period searching. This generally lumped under the term of wind turbine syndrome, and which can affect both humans and animals. There was a book written about the effects on humans, about the dizziness and the vomiting, et cetera, but I don't believe that book actually covered the animals. But since then, there's been more and more coming out about that. Briefly, the animals that I found stories about were horses, cattle, chicken, sheep, mink, and emu, both raised as farm animals. Wildlife, we've already talked about birds, but bats, whales, porpoise, dolphins, seals, and there's been reports about domesticated dogs with issues too. Just so briefly, again, a broad spectrum of animals. The apparent causes of this syndrome are stray voltage is one of them, otherwise known as dirty electricity. And the other category is that they suspect is a big problem is the vibrations, the low frequency noise, and the EMFs, which we've kind of touched upon here a little bit before. The reported effects include fertility issues, miscarriages, birth defects, mutations and malformations, as Lori mentioned, improper egg development, some eggs without yolks, some with thin shells, some that didn't even have shells, decreased milk production, aggression in mothers toward their own babies, sometimes even eating them. And that is only when the turbines were going, and only when the wind was from a certain direction, and otherwise they were fine. Failure to thrive, losing weight or not gaining weight, and death even, and we're talking about mass die-offs, big numbers of animals. The industry says these claims, they said human claims of wind turbine issues are psychosomatic and that injury to animals or humans has not been proven. Common sense says animal injuries can't be psychosomatic. There are reports of both animal and human health problems occurring immediately after the turbines are installed. Some health issues may be stress-related, but that does not make them any less real or injurious. Physical malformations are not psychosomatic. There must be a physical cause. And direct links to wind farms have not been proven because they haven't been studied. And so it's easy for the industry to say, oh, there's no proven direct relationship. Well, they're just refusing to do any studies on it, so of course there aren't. So, bringing it back to our concerns for Yankton County, worried about the potential human and animal harm, particularly with babies and pregnant moms, and that it could severely handicap and bankrupt a lot of our ag business, which Lori mentioned. And it could also have a major adverse effect on the local food supply. You start taking down the cattle farms and the corn crops and things like that, and pretty soon you got a food issue as well. So that's just my basic notes. And I'm going to give you a couple documents to take with you. Before I do that, I just want to say, the more I look into it, the more opposed I am to these wind farms. I didn't come in with an agenda or an idea ahead of time. When I started looking into it, this is what I found, and like I said, the more I dig, the worse it seems. So, what else was I going to say? But for the purposes of this group, which I know your job is really just to update the existing regulations. You don't have the say over whether these are banned or not. I am strongly urging the largest setbacks you can do, because it just seems like nobody really does know. And as someone mentioned, if you have interference with those seismographs 10 miles away, well, there you are. The animals are going to have those vibrations too. So anyway, the largest possible setbacks you can do is what I recommend. I'm leaving with you copies of wind farm development concerns. It's just a very brief list of all the different concerns we have over the wind farms. A brief article I printed off of the internet, which is a nice summary of the animal concerns about do wind farms harm animals, and kind of goes over in more specifics some of the things I mentioned. And then just sample articles, 2 of them about the minks and what happened to the minks. It's pretty shocking. So that's what I have for you, and I thank you for your time. I appreciate it. I do have some hard copies here.
Why don't you just give a copy to Gary and he'll scan it?
Okay,
and
sounds
send it
very
to all
good.
of us.
Thank
That'd be
you.
great. Thank you. Other comments before we start our meeting? Or discussion, I guess our meeting is going.
I certainly have not done the research that other people have done, so I will make this very brief. My name is Sharon Ackland. My husband, Dave, and I have farmed in the northwest corner of Yankton County for over 50 years. As you can see, we're retired, so we no longer farm but rent our land. My only comment is that Yankton County is very populated. In our area, within a mile and a half of where we live, we have 6 acreages. We have 1, 2, 3 farms, including our own. And so as you look at setback issues, anywhere you go, you're going to run into people. The closer you get to Yankton, the more populated it is. There are very few areas in Yankton County that are not going to be heavily populated. And so that's my message to you.
Thank you. Other comments? Sir? Yep, go ahead, sir.
Rodney Slutton, live west of Ivory in Yankton County. I was talking to my wife about the effects on the wildlife. I said, well, why don't we see this wildlife deformed and everything? He said, well, wildlife, it's the survival of the fittest. Well, the ones that they can't run because their hooves are all and legs are deformed, they're gonna be eaten. So wildlife itself takes care of its own evidence that it's harmful, so you're gonna have a hard time finding deformed wildlife because it's eaten.
Thank you, sir. Other comments?
Hello, my name is Thomas Conway. I live in the north side of Yankton County. I just want to voice my concerns about the impact that these wind turbines are going to make on the livestock and the wildlife, and they make an impact on just general quality of life with how they impact the livestock, the wildlife, and all the crops. Thank you.
Thank you.
I am kind of late coming to this information. My husband and I both own property in Turner County, but we also own property in Yankton County. We are right on the corner of Yankton and Turner County. In fact, if you look at the Mayfield Township and the Turkey Ridge, the proposed area, Pearson's Corner sits right dead smack in the middle of it. I own Pearson's Corner. There is a huge historical area in there because what you're getting ready to do with all of these turbines is take away people's history, their livelihoods. This could ruin our property values and take away so much of our family history by having these so close to our properties. And just coming into this and just learning about it within the last 2 weeks, I'm sorry. There's a lot of us up in Turner County and in the northern part of Yankton County that don't even know about this. And so we're getting ready to be blindsided by having all of this here. So coming late into this, I'm sorry, I'm very frustrated because the information up in that area, with it being so rural, is like this. So that's my concern, is that the people that this is really going to impact in northern Yankton County and in southwestern Turner, they know nothing about it. Because I've been talking to people in Turner County ever since I found out. They know nothing. And they're about ready to get blindsided. That's not right.
Thank you. Ma'am, what was your name?
Jackie Mayo.
Jackie May. Thank you.
Good afternoon, and thank you for the opportunity. I did not come prepared to talk about this. In fact, I am a recent transplant from north central Nebraska into Viborg. I know personally about the wind towers around people. I know personally, not from the internet, that people get ill, that people have miscarriages, that cattle don't perform the way they normally do, wildlife disappears. I know personally from some of those things. And it's not a good issue. But even the bigger issue than that affects every one of us, no matter where we live, is who ends up owning these. Recently, the Chinese government was stopped from purchasing land around a military base. That is smart. Why would we allow those same people to own land next door to us? While you cannot come out and say, you can't build here because it's going to say, but we're U.S. companies putting it in, which is quasi-true. The bottom line is you can make the setbacks, you can make the conditions impossible for them to come in. Without saying you can't come, you can say you can come if you do this and this and this and this. Things like huge escrows for taking out the towers when they're gone. If it's in escrow, because otherwise the companies are going to go broke we've seen it already in Nebraska, and there will be no money there except for the landowner who has to go bankrupt and sell out because they don't have enough money to decommission those things. There is not that kind of money except in big, deep, multi-corporation pockets. So do your due diligence, make the setbacks huge, make the escrow amounts huge, and so that they have to adjust them annually for what inflation and what travel prices, because you have to take those blades miles, excuse me. So yeah, you can't say no, but you can make it very difficult and try to do that for the good of the United States, not to mention Turner and Yankton counties. Thank you for your time.
What county in Nebraska were you in?
Holt?
Holt?
Mm-hmm.
Thank you.
Near Atkinson, O'Neill.
Yep.
Right. I was a rancher south of Atkinson. The wind charges did not affect me personally because I was 30 miles from some of them. But we're ranchers. We have friends all over North Central, and that's how I knew. These people, they couldn't sit outside in the evenings anymore because the vibration, the energy, the vortexes made them physically ill. I was at their houses. It does. Thank you for your time.
What was your name?
Barbara Steskel. Not a common name around here. Not a common name in Holt County either. Thank you.
Thank you.
Thank you.
Other comments?
Evening. I'm Matt Conway. I live up in the north end, up by Pearson Corner. I echo Jackie's frustration. My boy, he run across an article in a paper at the neighbor's house before I even found out about it. I thought stuff like this should be advertised maybe a little more highly. I know we're all like internet nowadays, and I'm a truck driver too, so I'm used to dealing with the government, and I always laugh at how far behind they are in the times versus everybody else. I don't want the windmills either. I moved out here 3 years ago, so I'm a transplant, and it's peaceful and quiet out there, and I like to hunt a little bit. And I drive truck, and I've been in the wind fields, and it is true. You can hear them growling and thump, 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 and the blades go around. And it always blows me away that anybody sign a lease to even put them on their property in the first place. They've been around. I've been driving truck for 20 years, and when I first started driving, it was windmills, and guys I knew would haul them. It's when they really first started pounding them in. So there's plenty of evidence out there. Number one, they're not efficient. They don't pay for themselves. They're honestly just a waste of money. So, I mean, I just read Texas 2022 just pushed it back to 10 times the height from when the blade is up to the ground, or I think 5 miles, I think it was. So there's studies out there. I would say put it back to 10 miles too. Backset from non-participating residences. So, thank you.
Thank you. Other comments? All right, we will close public comment with that. Thank you all for sharing your thoughts. All right, so it's been 2 weeks, and I made a few notes. I think the last thing we were talking about was our decommissioning plan. Robert was the only person that missed the last meeting, and I did send him some notes on what we had discussed, so hopefully he's kind of up to speed. We had gotten to Section E of the decommissioning plan. And this is termination of use. So one of the concerns we had here was currently our solar ordinance requires the solar panels and the systems to be removed within 6 months of the date that either the county requires them to decommission or they have alerted the county that they're going to decommission. And we thought 6 months was certainly not a feasible, if we've got, for example, let's talk about the wind farm that's maybe going in. There may be 40 to 45 turbines in Yankton County, assuming that half of them go in Yankton County and half go in Turner, because there's close to 100 turbines in the planned development. So to get down 40 to 45 turbines in 6 months is probably not a realistic achievement. I think, did I send out something about 18 months, 2 years for some areas that they had put in there? Is that ringing a bell to anybody? No? Maybe I just found it on my own then. See, it's been 2 weeks. We should have met last week. It's not fresh in my mind. So are there thoughts on that? Did anybody look into it? Yep, go ahead, Mike.
Sherry, I'm Mike Welch. I was thinking about the same thing after we met last time, and we're already requiring the developer to create a cost estimate for decommissioning. And having done cost estimates for radar and communication systems, I know that you have to create a schedule in order to do a realistic cost estimate. That's the baseline, is how long is it going to take you to do it, because that tells you how much labor you're going to have and so forth and so on. We could require the engineers who do the cost estimates to also do a schedule, a proposed schedule to completion of decommissioning, and that would solve our problem. I sent some language around to the whole group. If you didn't check your emails this afternoon, you didn't see it, but I did put the language in there, and basically what it would say is under E sub A, actually we'd have to go back up to capital B, cost estimate, and item A, I said, the cost estimate will include a proposed timeline for completing the decommissioning process. The cost estimate shall provide the estimated cost and schedule for decommissioning. In item C, I say the cost and schedule estimate above will be reviewed and analyzed by a third-party engineer of the county's choosing. And then in item D, I say the applicant or its successor shall update the decommissioning cost and schedule every 5 years. So I'm including that idea of schedule all the way through this in the estimate. And then down here in E, where we have termination of use, I refer back to that. In the last 2 lines of E sub A, I say decommissioning in full accordance with the decommissioning plan and schedule. In item B, I say if the applicant or its successor and/or landowner fail to decommissioning the wind energy system within the time allotted by the decommissioning schedule. So I'm referring back to that in all cases. In other words, I've thrown enough language in there to adjust it from being 6 months to be the schedule that the engineers determine is appropriate. And that way, if it's 10 turbines in Yankton County or 40 turbines, we're going to have an engineer's estimate of the schedule for completion of decommissioning.
Okay.
The problem with all,
Go ahead, Don.
Go ahead, Don.
the problem with all of this, that, Mike, is that you got it in writing, you got it in, but nothing's forcing them to do it.
That's true.
And you're gonna end up with farmers spending gazillions of dollars of their money to fight legal expenses to get them to do it. And if those companies file bankruptcy, and it could be years. So whatever our language we got, it doesn't say our problem is solved. It says we took the steps to cover our ass, but it doesn't say the problems were solved.
Right. Right. Well, I'm in favor of whatever is the most strict interpretation of schedule we could come up with. It's just that if we put a number of months or even a year on it, how do we know if that's correct? We need a professional to tell us what a workmanlike process of completing decommissioning would look like.
And who would we have pay for that?
The
Engineer.
cost estimates are paid for by the developer. Both
So you know how he's gonna.
Yeah.
You know how he's gonna have them write it up.
Right.
But you're going to have these schedules when you're getting the CUP. So as commissioners, we would have that information in front of us before this even gets approved. So that is part of that enforcement, because if the schedule doesn't look feasible, or if the schedule is ridiculous, then, you know, that's, I mean, we're gonna have a lot more of that information in front of the project rather than finding out on the tail end of it.
Correct, and it needs to be in writing.
I agree with
So-
that.
So
yeah.
I think your proposal is solid. The concern I have is, what is a reasonable time frame? So can we add something to say not to exceed?
I'm in favor of that.
I mean,
Certainly.
3 years, something not to exceed, because if they come back, to Don's point, the engineer works for them, they say, well, it's gonna take us 10 years, because we're kinda short on guys, you know, that's not reasonable, so there needs to
What
be.
can you do when the 3 months or 3 years, or what can you do? You can do nothing.
Well-
You go to court and you fight them,
Yeah,
and it costs people money to do
Yeah.
that.
Yep, but the thing is, part of our plan is to have the money in the pot already,
Part of it.
right.
all of it, by the 10-year mark.
That's why the cash escrow is so important.
And so that money is sitting there, and the county's in control of it
So if you put a
until it's
cap-
executed.
So if you put a cap, say it has to be done within 3 years, then their decommissioning plan and the cost of that decommissioning plan must be covering
We're working on that.
for removal within 3 years. And so the concern here is that, you know, they could say, oh yeah, we'll do it within, you know, an unlimited schedule. Though you can really make a really light, you know, a low cost
So their
decommissioning plan.
escrow payments are nothing, or
Yeah.
very little, and yeah.
So does that seem reasonable if we, somewhere in here, say not to exceed 3 years?
I agree
I
with
say 3
everything
years sounds
that's
pretty
been said.
reasonable, very reasonable.
Yep.
Okay.
I think 3 years sounds even a little generous. I don't know
Do
that.
you want to do,
I don't know
2
that it
years?
should take, I mean, gravity is working against construction. So it shouldn't take them any longer to take it down to put it up. So if it took them a year to build it, they should be able to get them down in the same amount of time.
I think 2 years is still very generous. You know, again, because you could always have, we've seen years of really bad weather that can really put some projects behind. So you know, very rarely do you have 2 bad years in a row. So
so thoughts on that? Right now, the last number thrown out is 2.
Yeah, I like to.
I like to.
2?
Who's good?
Right here.
Okay, so we'll do 2. So we'll, I think the language you've added, so I'll look at the email, and if everybody's okay with Mike's, yeah, go ahead, Mike.
I'm gonna follow up on Don's comment about putting together a plan and reviewing it and noting how that needs to be analyzed. Do you go so far as to expect an independent accounting firm to certify the plan, or at least express an opinion on the plan, to assist the county, which would be part of the cost of developing it in the first place? Because
It's all about enforcement, Mike.
what's that?
It's all about enforcement. You can make any little rule you can on time, but how do you enforce it?
Okay.
What are the enforcement procedures?
Okay, but the money would be already established for the development. I'm just assisting the county here in the monitoring of it.
and I agree with you. You know, almost everything we do, once it's in place, it's going to be really hard to enforce anything. And so that's why I think, you know, our real only enforcement is a denial of the CUP and saying, no, this is not complete enough for us. And so if we have all these things in there, more requirements that they have to fulfill, that gives us more insight into how, you know, that, you know, maybe this CUP is not a good one to pass forward, you know. So I think that's really, as a county, that's our only enforcement level, is denying the CUP. That's like first and foremost. So having as much information up front and having accurate
I
information up front
understand
is the
what
most.
you're saying, Ryan, so 10 or 13 years after it's shut down and it's still standing there, That's the enforcement I'm talking about.
Mm-hmm.
Yeah. Well, there's a simple way to solve that problem, and that is that I made a proposal early on that we could simply state large commercial wind energy conversion systems are prohibited in Yankton County. That solves all problems.
Well, and I hope that we'll get a chance, who was all present, to take a vote on that before we forward the final recommendations. I like the idea of generally having somebody look at that to give a time frame, and then say, as long as it's done within 2 years or the escrow's triggered. And I think just make that very clear that there is an upper limit. And then what happens when that upper limit is passed.
And all that's fine, but all that,
The court is ultimately the enforcer.
Yeah,
but the clearer you make it, the easier it's gonna be.
but as soon as they can file an injunction and stop everything, and you're in a 1 or 2 year court battle. And a lot of that's gonna fall back on the county, and we don't get nothing for this.
Excuse me, what happened to the escrow money that's set aside and fully funded as this wind power is set up? That money is there and available.
Until a lawyer files a document that says you can't do it until our court case is resolved. And that can take years.
Well, I don't know about that. I think the legality of that is pretty well covered at the origin of the document. It's pretty clear, and I don't think there's a way out of that. But I'm not an attorney, and we can all second guess this, but that should be pretty well covered in the escrow account with the money that's
So
set
you're gonna
aside.
tell me when a squatter can move in the house and be there for 4 years, although there's documentation that this other person owns it, that even if he had an escrow account, it makes no difference. The
I don't
house is
think
ruined,
that's a
it's
fair
gone.
analogy, actually, Don.
Well, it's the same thing. The law doesn't support, the good side, the side that has done all the documentation. We're expected to go in and defend it, fight it, and fight it. And then when you get done fighting it in the court, then you got a period of time that you can maybe go out and do something.
Well, I would stand with my statement here that that is an utterly false analogy that really isn't applicable in this situation.
All right, so that said, can we move beyond item E now? I think the only thing in there we didn't really discuss was that time, that 6 months. Mike, did you have something else?
Yeah, down in C, in the next paragraph down.
Yep.
This would be EC. It says the landowner is ultimately responsible and could have a lien placed on their property should the applicant or the successor fail to fully remunerate the decommissioning cost. Okay, could have is, will there be a lien or will there not be a lien? Who determines it says could be? So I'm a landowner out there. What's my exposure?
So what triggers?
Well, the landowner's getting paid to put them up, the participating landowners. The non-participants, there's nothing in it for them, having them put up, but there's a lot in it when it comes to decommissioning. And so, again, you can put in whatever you want. It's enforcing it.
If you just change the word could to will, that,
Doesn't make any difference, it's still enforcing it.
right. Oh, yeah.
Well, actually, you can say that about everything in our ordinance. Everything's about enforcing the ordinance, the speed limits, paying your taxes. I mean, there's people out there who don't pay their taxes, how do we enforce it? We put a lien on their property type stuff, so, I mean, if you don't do something strictly because of enforcement, I think that's a poor reason not to do something.
So if you set and then I'll shut my mouth. If you set a speed limit sign of 30 miles an hour, and nobody ever enforces it when it's going 70 or 80 or 90,
Yep.
what good is it to have the speed limit?
A lot of people have asked those questions, especially on gravel roads.
Well, a tax lien is a pretty powerful incentive. We have language in this proposed decommissioning plan that says that if all else fails, meaning the cash escrow and the failure of the wind turbine company to decommission, if all of that fails, the county is authorized to place a tax lien against the value of the landowner, and that tax lien is enforceable in the current year. And so I don't like the idea that we're jeopardizing the ownership of citizens of Yankton County. However, as Don pointed out, and I think I said last meeting, if they're willing to exercise their authority to receive rent payments for a wind turbine on their land, they must also accept the responsibility ultimately for decommissioning. And that's very strong enforcement.
You know, I think it was pointed out early on in some of the public testimony that there was a county in Iowa that emphasized that the landowners were gonna be, to some extent or at some point, the final hook for responsibility on the decommissioning. And he's pointed out that as a result, there were no wind turbines in that area.
Yeah, I think it was
Because
Sioux,
everybody's quick to go to the mailbox for the check, but not so much for the other.
I think it was Sioux County.
Was, okay.
Yeah, up on the Big Sioux River.
So on that note there, we could insert before the sentence, should the escrow fail to cover the decommissioning cost, the landowner is ultimately responsible and could have a lien placed on their property should the applicant or its successor fail to fully remunerate the cost of decommissioning.
Yes.
That language is already in subparagraph B at the end, it's underlined.
So it's 7 years. I believe it's 7 years you have to wait to act on a tax lien. Whatever.
Yeah.
It is not an ideal schedule if that happens. It is never an ideal thing when you have people who don't do things that they're supposed to do, and it's never going to be.
Okay.
When you're dealing with a bad actor, it's never going to be ideal.
So we don't need to add that note then. Thank you for pointing that out.
Right.
Okay, so I'll say one more time, item E, A, B, and C. Are we pretty good with that? With the changes we discussed about the 2-year and then the addition of the other language that Mike had sent out? Okay.
Yes.
So, okay, so let's cross that out. So now we're on to F, which is liability insurance, and I'll read it for the benefit of the audience. The applicant or its successor shall obtain and hold a general liability policy covering bodily injury and property damage and name Yankton County as an additional insured with limits of at least $2 million per occurrence and $5 million in the aggregate with a deductible of no more than $5,000. The applicant or its successor must provide proof of insurance to the zoning administration prior to construction. So that language was taken from our current solar ordinance.
So is this, our solar ordinance, we have a much more compact system.
Correct.
This is a very large, widespread. Is this a 2 million per occurrence? Is this for the entire, all,
Event.
for all the locations out there, you know, because we're gonna be on multiple parcels and
Mm-hmm.
Yeah, I think the risks are gonna be far higher with a wind turbine versus solar. They will burn, but only if there's fuel provided. They're producing a DC, not AC. It's a wholly different, it's a different approach. Based on the fire potential of a turbine, we had $10 million of damage come out of a negligent farmer's burn pit that was at ground level with unfavorable wind conditions and dry. When you give something a 400-foot height to broadcast from in windy conditions, I think just the fire potential should be triple this, many times this. This 5,000 acres was 10 million, and that was not as bad as it could have been. So I think these limits are too low for wind.
Thoughts?
I agree. You know, my wife's business is forced to carry higher insurance. So I feel like this is very light.
I mean, farmer, general liability policy for farmer 1,000 acres or over is approaching 5 million anymore, to my knowledge. Or should be.
Could you just simply say 2 million per turbine? At each turbine site? And there is no aggregate?
See, the problem is with fire, now, in a turbine, with the other things in place, there's not much a single turbine can do to crash down but fire will go on its own way outside the footprint of one individual machine. You know, that can blow, but we had 40-mile-an-hour winds that day, and it covered one end of the county and ran out the other side of the county.
So are you looking to maybe up it to 5 million per turbine?
Well, I don't know, it's just, I think per event, it needs to be $5 or $10 million per event. If that
Per
comes
event?
from 1, 2, or 10 turbines, I don't know. It'd probably be a single one if it's a fire failure. But I mean, that kind of, you can't get water on it that far in the air, so it's gonna continue to burn, and if it's a burn condition that's gonna carry, I mean, I don't know, we wanna be on the low side of that one.
5 million per event?
I don't think we have the expertise to determine what it should
do
be.
that.
It might be a good idea to get some advice from an experienced
Okay.
casualty insurance underwriter,
All
if we
right.
have one in the county.
And of course, the hard part about this is that we're talking again, insurance for today. This is something that changes 10 years from now.
Yeah.
Okay. So I triple starred this one to further look into a little information there, so Gary, make a note of that. So we certainly want to keep that in here, it's just the amounts associated with and how to describe, is it turbine, event, you know, what's the year limit, et cetera, okay? So the next item is indemnity. Developer shall hold the county and its officers and employees harmless from claims made by developer and third parties for damages sustained or cost incurred resulting from said WEX project. The developer shall indemnify the county and its officers and employees for all costs, damages, or expenses that the county may pay or incur in consequence of such claims, including attorney fees. Third parties shall have no recourse against the county under this agreement. So that again was taken from our current solar ordinance.
Seems okay.
Good there? Okay, so that is the last bullet point under the decommissioning plan. So we have walked through that in completion. So we've got a few changes we made, and then we still have a question on the liability insurance. So the next item we need to cross off our list is Section 2617 of the newly organized, it's in our old ordinance. Oh, where is it? 15. Oh, I don't even have it. Why did I say 7? Facility setbacks. It's item 19 of our old ordinance. I'm not finding it here. Maybe my papers are out of order. Oh, here it is. No?
Technical issues and expert review.
Yeah, yep, that's what it is, Robert. Let me open up my old ordinance. Did you, yep, perfect. So this is kind of, it says, WEX and equipment facilities may involve complex technical issues that require review and input that is beyond the expertise of county staff. The zoning administrator, planning commission, board of adjustment, and/or county commission may require the applicant to pay reasonable costs for a third-party technical study of a proposed facility. Selection of experts to review will be at the sole discretion of the county. So that's in our current ordinance. I think it's decent language. It's kind of a catch-all for everything. So I do think it should be included, and forgive me, I know it's,
That is in your thing under agreements and studies F,
there we go, thank
word
you.
for word.
Yep, so that language is there. So I'm a proponent to keep it. Does anybody have a reason not to? Okay,
No, I think that's a good catch. Are we gonna go through we gonna review through the whole thing now?
yep, I think we need to go back. As I noted, there's some language I put in here. Drain tile
I see, so
Has-
saw the notes.
has been an issue, and I think I'm missing a page here.
That's right away and F, under mitigation measures.
There we go, drain tile. So, and I think I stole this from someone, some other county. So the permittees shall obtain maps of all known drain tile installations, and with the approval of the landowner, the permittees shall utilize construction methods that minimize the impacts to existing tile systems. Is that reasonable?
We talked about saying a depth. Do we wanna say 6 feet?
Well, we also had talked about the landowner having the control to override that.
Well, he could give a waiver of that.
Exactly,
Okay.
exactly.
So what are we trying to say here? I mean, if there's no maps, which in a lot of cases not gonna be.
There aren't. Yep,
So do you say that they are responsible to the landowner for drain tile damage?
correct. Do you want to add that language in there?
Maybe as a finisher on the last sentence.
The permittees are responsible
Shall
for
use-
any damage?
Yes, and will be responsible for any damage incurred. That way they can figure it out.
Other comments? So BF, tower height. So this is under design requirements, it is item E, and it was requested a few meetings ago to discuss a tower height limit. And so that's where I put it in there. Now's the time to discuss that.
You guys that went to the prevailing winds project, if I remember right, one of you told me that those wind turbine towers with the blade and its fully extended vertical height were slightly less than 600 feet. Isn't that right, Rob?
Yes.
I don't know if it was you or Mike. Somebody told me that. We could use that if you wanted to.
But again, here we go into the,
Yeah.
where the industry's going, cause they're gonna wanna be at 800 here, I think, tomorrow. That's one of the benefits of the bigger setbacks, because you're gonna see that sucker from miles away, whether it's 500 or 800.
Yeah.
That kind of impact on this, the area is not gonna change very much. 200 and 300 feet, when we're talking about the size of these things, is not that big a deal. But I think we protect ourselves in the setback, the healthy setbacks, you know, in several of these things. I think that's one of them. Because they still have a tower height, 1.5 times tower height, even from the participating. So that just kind of self-regulates. But it should at least reflect the height that we know is reasonable in the future, which is gonna be the 800.
We need to have an upper limit. I don't know what it should be exactly, if it should be 6 or 8 or what, but as far as I can tell, the industry's moving to towers that could be in excess of 1,000 feet. And if they do, we need to have something in our ordinance that says not here.
Well, maybe the 1,000 feet will give us a number, at least buy us some time, because we can't, you know, you can't forecast everything.
No, but again, keep in mind, we're not here to try to facilitate the wishes of State Street, Vanguard, BlackRock, and JP Morgan Chase, who own these companies. We're here to protect the interests of the citizens of Yankton County. That's our purpose here, is to defend the citizens of the Yankton County against an industry that may wish to do a Tower of Babel, for all we know. So we need to, I think we need to put in an upper limit that probably reflects the current state of play, and that is the current state of play, 600 feet. And if they want to come back and jawbone us into making it higher, they can do that. Just keep in mind, no matter what we do, it's always easier to lighten up than it is to toughen up. In other words, if you're going to go in and you're going to set a limit, keep that limit good and tight. Later on, you may find out that your limit is too tight and you can loosen it up a little bit. But if you walk in and you're trying to be Mother Mary, or you think, oh, well, I'm going to set an upper limit that's real high, and that way everybody will like me, you cannot toughen it up. So I would suggest a tough limit, and if somebody can convince us it needs to be greater, so be it.
Those are great comments, Mike. I think our best, if we don't want to facilitate and be part of this, we say no and no turbines, period. Okay, that's where that goes. But if we are going to entertain it, it needs to be realistic, in my view, of what the industry is going to require to do this. And I think with a healthy setback, the height becomes less important. Now, I'm just looking at 3 different counties here, and where it's on max height, they have none.
So.
No, there are none.
I'm referring back to my spreadsheet of all the counties in the United States, and out of all height restrictions, the tallest is 750 feet. The most common is 600 feet or 500 feet for height restrictions.
Let's go with that.
So I'm going to ask the first question, do we want a height limit?
I think we do.
Okay, so do we want to go with the national average, 500 to 600 feet? Or do we want to go to the 750 or somewhere in between? If Bonhomme County right now, the folks who went over there, those are 600. Do you want them taller than that? I guess would be my question. Do you want to see something taller than that?
I think the highest I can allow is 600 feet.
600.
I feel that's as tall as I'd want to go.
Okay.
I support that.
Don?
I kind of like 500, but I think the industry is.
I'm not sure it makes a lot of difference.
Yeah.
I sit here west of town, and I can see 30 miles away. I don't know whether they're 200 feet or 300 feet, but I can see them.
Especially at night with the blinky lights.
Yes. So,
Lauren, you've been quiet.
Yeah, no,
Okay. Mike and Mike,
I'd go 600.
600?
What-
Okay, so for right now, we'll get language in there that the maximum height is 600. All right, so that was a flicker analysis. So that would be under studies. Our current ordinance does not have anything to do with flicker in it. And so if you look under agreements and studies, I borrowed that language from somewhere. So I will read it. A flicker analysis shall include the duration and location of flicker potential for all schools, churches, businesses, and dwellings within a 1-mile radius of each turbine within a project. The applicant shall provide a site map identifying the locations of shadow flicker that may be caused by the project and the expected durations of the flicker at these locations from sunrise to sunset over the course of a year. The analysis shall account for topography, but not for obstacles such as accessory structures and trees. Flicker at any receptor shall not exceed 30 hours per year within the analysis area. Exception, the Board of Adjustment may allow for a greater amount of flicker than identified above if the participating or non-participating landowners agree to said amount of flicker. If approved, such agreement is to be recorded and filed with the Yankton County Zoning Office. Said agreement shall be binding upon the heirs, successors, and assignees of the title holder and shall pass with the land. So the first thing I'm going to get comment on is it should be filed with the deed,
Yes.
correct, instead of just the planning office.
Yep.
So I'll make a note of that. Other changes, that may have come from Coddington. I can't remember now.
I think it should be 2 mile to reflect the setback.
2 mile?
And I don't know if the language in we could certainly keep that in there, but it seemed like on the visit we had to the wind farm, the people and computers are smart enough that they know the solar tracks, they know how stuff moves, they know the shade analysis, and this is all preventable. So they actually take the machines that happen to be blowing at that direction when the sun is here and this is there, and it's not there. So they can take that out. So I would maybe add the language that if determined flicker can be mitigated, it should be, or something along that side, because I think they can take passive, it's a computer setting, but it just doesn't occur, because they know when it would occur, they know where it would be, what it would hit, when it would be, and they just are able to deal with it to the software, which is incredible.
Other thoughts?
Yeah, the prevailing winds document here, their Article 17. And we had an example over there when we visited there from the manager about a perceived flicker that they took care of through this program. And they also had a situation, which I think was different, where there was a perceived flicker and an investigation was done and they discovered that yes, there was, and that was adjusted also. I think they have, the point is, as you were saying, the program can be set to eliminate this problem quite effectively, and the language that is from Bonham County here is fairly good to do that, I think.
Yeah, if the technology's there, they should absolutely exercise that, because then the problem really goes away.
Right.
That's a nice way to handle that, but we should recommend that if it's available or whatever, they should use that, and everybody will be happy on that account.
Okay. Let's see, language, and that's from which document?
Article 17 of Bonham County.
Article
That would be more than recommended, you expected, required,
3 of 5.
rather than just recommended.
Yeah, it should be, if it's available for use, it should be used.
Okay.
Or required for use, even better.
Perfect.
Now, the shadow and flicker is something that you can physically see. You can stand there on your front porch and, you know you're getting blinded by the wind turbine. Okay, that's kind of cut and dry. The one I'm not seeing in here, though, is the vibration and the ULF.
Yep,
So,
probably because I couldn't find anything on it.
it's a hard one to get your arms around because it is still in a state of flux in terms of what and where. I mean, soil types and, I mean, there's so much involved in this. I think we're just kind of scratching the surface. We might want to keep it as a topic, maybe to be addressed in a study of whatever format the
Okay.
developer decides upon, because we don't have any standards or Röntgens or measurements to exercise. But I think on this other one, we had one where we had kind of a catch-all kind of thing. It was on electromagnetic. Yeah. Okay, somewhere where if we have these, if you have measurable ULF, if you can prove through the documentation that there's adverse effects, then action has to be taken. Or something to that extent, because you can't say 35 decibel, you can't say this many wavelengths, you can't, there's no unit of measure that you could apply. I mean, just ULF covers a pretty broad spectrum of radio frequency.
It already has, like you said, permittees should take the measures necessary to correct the problem.
Yes. So maybe we just electromagnetic interference / ULF and put it in that same category.
Ultra low frequency, there we
Yes.
go. I had to catch up.
Vibration. Now, this one speaks to FCC. FCC's not gonna have anything on that. We may have to, just tweak it to make sure it's included. That if it can be shown, through documented evidence, and there's guys that go around and do this kind of stuff, but it takes very specialized instruments to document and record and all that. But if it can be shown to be a problem, it should be something that's addressed.
Ryan, don't civil engineers have standards for this kind of thing when they put in highways and airports and those kinds of things? Wouldn't you think, I'm asking you because you're an engineer.
Yeah, not exactly my expertise area, but yeah, there is some standards out there regarding, and SEC may have some things in there if there is any type of remote communication device on there, but I think it's fine to just leave the FCC in there. Anything they use will be governed by them anyway. Yeah, I don't, I think our electromagnetic interference paragraph here is fine. You're not gonna see a huge EMF issue
No,
from
and that's
wind
fairly
towers.
measurable through.
Yeah, and it's very measurable.
Your VCR display is gonna tell you something's going on if that kind of stuff is out.
Mhm.
But ULF is not.
Yeah,
That's
ULF
kind
is a
of
little
the
harder.
invisible guy at the table here.
And ULF, well, that's where your seismographs pick them up.
Well, maybe it's
but-
something we have just its own paragraph on, that the applicant do their best to provide information regarding generated ULF fields.
At the end of the day, our biggest protection on ULF is our setbacks.
I agree. No, I agree. And once again, the healthy setback solves a lot of this.
Mhm.
But I don't want to at least not have the very topic in there. It should be, even if it's very cursory, because that's all the kind of information that's available anyway, it should still be one of the items.
Gary, can you pull up the District 3 setbacks, the maps that they provided us?
Yeah, they're right behind you.
I mean, everything we're talking about so far is kind of mute, depending upon what the setback is.
2 miles, I'm hearing
Hard
10.
copies, but you want them on the screen?
2 miles takes care of everything.
That's quite a
Might be
bit.
better.
Have you seen the map?
Yeah.
That's a map of 2 miles without the wind developer saying, hello, Mr. and
No,
Mrs.
this-
Landowner,
This is a, this
can
is
we do this?
District 3, oh, well, okay, yeah.
Because that could change, that's subject to change. And
Okay,
to
yeah.
go non-participant
Yeah,
to
yeah.
participant.
Yep.
Sent it to you all.
I'll get it figured out.
All right, so I will look at trying to find some language to maybe address that.
Something that we want it diminished. Just kind of general catch-all thing. We don't have to get a lot of detail, but I think as a topical thing, it should be in there because I think the information is gonna be more forthcoming.
Okay,
Yeah. Take steps to minimize something like that.
And it may be, a lot of it, is soil type and, how big the foundation is. There's passive things I'm sure they could do to minimize it.
Right.
Or have canceling signals. I mean, it's not rocket science.
so while Gary's booting up there, the next item that we needed to circle back, because I put language in for endangered species, wetlands, and mitigation, so that's C. Applicant must submit an inventory of any existing endangered wildlife, flora, and fauna species in biologically sensitive areas and meet all South Dakota Department of Agriculture and Natural Resources and South Dakota Game, Fish, and Parks requirements. Applicant must examine landscape levels of key wildlife habitats, migration corridors, staging/concentration areas, and breeding/brood rearing areas to help develop general siting strategies. Applicant must situate turbines so they do not interfere with important wildlife movement corridors and staging areas. And that is the word must. So I think that was a hybrid of language from solar and some I stole from somebody.
I like that. You may want to put analysis after migration. Is all maybe.
Let me see.
Endangered species, wetlands, and migration analysis.
Also, at the end of the second to the last line, I would strike out the word important, because that is subject to someone's opinion as to what important means.
Okay, Do not
Applicant
interfere
must
with
situate
wildlife.
turbines so that they do not interfere with wildlife movement corridors and staging areas, period.
okay. Other comments? All right, we'll cross that one off. That's still booting up. Power purchase agreement. And that, we have to remember, we're not asking the wind turbine company to say, well, this is how much we're getting paid from whoever. This goes down to 50 kilowatts. So we want to make sure the people who have a 60 kilowatt turbine they're putting in have some kind of an agreement with BY Electric or who is it on the other? Northwestern. So if the applicant has an executed power purchase agreement at the time of application, the applicant shall provide with the application either such agreement or at the applicant's discretion, an affidavit of non-confidential information regarding such agreement. So that's essentially saying, hey, you need to make sure the power company knows you're coming.
I spent some pretty good time with the PUC folks on this. 50 kW, well, 10 kW and below is, you can actually, has a semblance of net metering in a crude way, 10 kW and less. If you want to go larger than that, 50 kW is a hard stop. It is a net billing. And even though it's not the same as what the big guys would have in terms of paperwork, it is still essentially a power purchase agreement, because you're gonna make anything above 10 kW if they have their way, is gonna go right to them. You don't get to use it first. It is gonna be a discrete agreement that's metered with a rate and all that. So even the little guy is gonna have that. Now, always looking for the exceptions to the rule. There is a possibility that systems that do not deliver energy back to the grid may be, will not require a permit from the power company at all, because they don't meet the definition of interconnection.
Right.
Now, so, I guess it's just an FYI, because you can't, you know, the thing would be 1,000 pages long if you try to think of every possible scenario. I think that one, the chances are probably small, but it may occur, that you're gonna have a 25 kW who's all battery and does not have a power purchase agreement.
Right.
Well, 25 kW, this doesn't apply to.
Okay,
So anything
51.
over 51, yep. But if they're 51, the state requires them to. Unless they're not.
Unless they're not given a take in it.
So, do you want me to put a clause in here that says if you're not
Less
connected?
than 50 K, it's gonna be pretty slim. It's.
I mean, if you're over
a
50
battery
K,
bank over 50 kW.
that's pretty
to
big.
offset onsite costs.
It's a pretty big system.
Yeah, I
So,
think we can live with that.
Think we're pretty good? That was, it's the exact language from solar. Okay, so Don, your map's up. You wanna talk about that?
Well, let's go to the first one, Gary. Go, put the distances on. I just want people, I just want the
full
people.
mile.
Start with 2 miles.
Oh, 2 miles has 0.
2 miles. They
Zero.
didn't even view because it was 0, yeah.
Okay, 2 miles is 0 locations.
Yeah.
Yeah.
This is a 1 mile setback is what's showing here.
That's a 1 mile setback, and,
It's pretty much those little red pieces there.
Yeah.
are the only ones with a 1 mile.
And then this is a half-mile setback.
And the red areas are
That's
Where it's possible.
where it's possible.
So-
Without the
The agreement.
agreement with.
With the clause,
with the
this is
landowner.
assuming nobody is participating at a half-mile setback.
yeah.
So in there, some of those centers could be participating landowners, so those would go red,
Mm-hmm.
unless they overlap with somebody else's circle. So that's a half. Now, you remember, our current ordinance is a 1/4 mile. Pretty sure it's 1320.
1320 feet.
1320. For you folks in Turner County, your setback's 1,500. I would, if you're from Turner County, I would go out, I think their website has their ordinances on it.
Well, if we're participating, and if we're 600 height, that's only a 900-foot setback to a participant.
Correct, but I'm just saying, if you're a participant, I'm assuming that your bubble is gone, just,
But you also have to think about from the company's standpoint, with these very few locations that are up there, how do they economically tie a 40 or 50 wind unit deal? It's not possible. They don't wanna run transmissions lines and all the lines that they have to all those locations, I don't think.
But Don, wouldn't that be, that's their problem.
Yeah. When we talk about a participating landowner or a participating parcel, I think we should be saying a participating parcel, that this parcel is a participant and it has to travel with the deed. Now, would they be able to have a participating parcel that does not have a windmill on it, but they do get the agreements that it is considered a participating parcel?
yep, I would read it that way, that
Yeah.
their land is participating.
So that means that with, those red areas is where you could be a participant and they don't have to get anyone else's
Yeah.
permission to put up a windmill. Now, if they really do their groundwork and really, maybe they could find a section in there, but they would have to get to every landowner and they would have to have very strong participation from the people. And I like the idea of that if these things are going up, they better have 100% of the people's support.
Agreed.
So if we were looking at property line, non-participating, 2 miles, non-participating, 2 miles.
So you guys want to talk about setbacks again right now?
I guess we're here.
I was gonna say we're here. The other things I had on the list was definitions. But those, actually, the planning commission can take care of definitions, so, setbacks, I think, is probably the last big key item that we need. So for the audience's benefit, as of right now, our current ordinance is a 1/4 mile. Whether you participate or not, that's what the current ordinance is. So what we have proposed so far, so for a resident, active church, business, or school, if you are participating, it's 1.5 times the total height. So our maximum height we've proposed is 600, so that would be 900 feet from your home, if you are participating. If you are not participating, it is 2 miles. And in the state of South Dakota, there's nobody at 2 miles. Lincoln County went to a 1/2 mile, and their wind turbine facility went away. That was a huge, I don't know if anybody remembers that, years ago, it's probably been 10 years maybe by now, but they pushed through a 1/2 mile setback, and their wind turbine facility went away. Now granted, Lincoln County probably has a few more residents, but I would say there's places in Lincoln County that look just like the northeast section of Yankton County. So right now it's 2 miles for non-participating municipalities, 2 miles. Rivers and streams, 1 mile. Right-of-way, 1.5 times the total height. Property line of a participating is 1.5 times the total height. Non-participating is 1 mile. So you might live here and you own property over here. So you have a 2-mile circle around your home, and this plot has a 1 mile from the edge of that property too, even though you don't live there. That is how this is set up right now. And then we had talked about floodway, floodplain, and I think Gary had sent out some things that the floodway, they probably wouldn't be able to build in just because of the structures and stuff. But floodplain is something we probably still need to discuss. The reason we didn't allow solar in a floodplain is because solar is about this far off the ground and the floodwaters are here. If you have a 600 foot tower and you've got floodwaters, it's not gonna hurt your tower. It's kind of like having a cell phone tower. So I think we do need to talk on that. That's probably the lowest priority of everything on the list. Yep, Mike.
Are you finished?
Yep.
Okay. I was, when I called you and didn't get through to you today, I was gonna make some comments, and this has to do with that setbacks. And the comments, we've heard them, many of them additional with the speakers tonight that have commented about, 3 to 4 miles, and the message that came through Tuesday night. I received 3 calls yesterday, and the key message was setbacks and also their property and what's gonna happen to the property as far as flexibility if their sons or daughters or family wants to develop it and they're all not participating. And I think it's also interesting to note that today I went to Xterra, their website, and I pulled up, and the first 2 pictures, or the first pictures that came up were of seeing wind turbines and out over a distance. And I have them on my phone, so no one wants to look at them. And there's no farms, no development or anything as far as you can see. So I think the message that comes through is that a comment that was made earlier is that really in Yankton County and with Sharon, I think, is the one that made the comments, with the number of farms and utilities or farms that are there, I think a minimum of 2 miles setback for non-participating should be changed. Or, excuse me, I would suggest that or recommend it.
From the property line.
Property line, that's right.
So I'm gonna write down that
Brian,
note here.
can you scroll that up? So we can look at the bottom portion of it.
While Ryan's doing that, I was at the meeting with Mike on April 2nd at Spring Valley Lutheran Church, and we started at 7 p.m., and I had to leave at about 10 p.m. because I had a 6 a.m. meeting the next morning, and there were still a lot of people there, and I did not hear one word in favor of the wind turbines in their area. Now think about this. There were about I would say between 150 and 200 people packed into that church. It's probably the fullest it's been in quite a long time.
I would guess.
The church that does accounting said we had 230 people there.
All right. There were 230? Okay, so what I'm getting at is I did not hear, these are the local residents, Yankton County citizens, not a word in favor of a wind turbine in their townships, those two townships, Mayfield and, is it Turkey Valley or Turkey Ridge? Okay. Turkey Ridge.
The township is Turkey Valley.
That's what I thought.
Yeah, the
But
township is Turkey Valley.
anyway,
Yep.
the point is, not a word in favor, and when I left, people were still, I mean, it was a vibrant conversation. People were upset. And so, if we're gonna lean in anybody's direction, I'd suggest leaning in the direction of the citizens of Yankton County. And as far as the 2 mile setbacks are concerned, this puts the onus on the developer. Our ordinance, the way we have our draft currently set up, is 2 miles from non-participating. So if I say I don't want it, it has to be at least 2 miles away from me. But if the developer, and believe me, they are deep-pocketed, wants to come to me and pay me to make me a participant, they can do that. So I think this is a very democratic thing to do, is to give the citizens of Yankton County the opportunity to say yes or no. And that's the way we currently have it drafted. I wouldn't change a thing. If Mike wants to change the property line number to 2 miles, that's perfectly fine with me. Go ahead, Don.
We were just visiting here, I think on our map here, when they drew it up at District 3, they didn't include the distance setback from rivers and streams.
Correct.
Yeah.
Because you can see a huge amount of that
Yeah.
brown is in the middle of the Missouri River. Or
James.
the James River, I guess, the James River. And of course, there's Martin Creek and all those other ones. I bet half of the current red up there disappears when you put those setbacks from rivers and streams in there.
And I think I think this map, Gary, correct me if I'm wrong, but I think this really is just putting that setback around every residence, church, and things. So it's not even
It's not doing the
lines.
property line, no. No.
So when you add in the property lines, even under a half mile, all that red goes away,
Yeah.
because that would be a lot.
I think that's why initially they probably went with the 1320, because that was probably talked about at that time too.
Well, and back, you have to remember, this is it 20 years old, Gary?
Yeah.
Wind towers weren't big back then.
So when we talk about setbacks, realistically, almost any setback is gonna totally eliminate.
I like the idea of keeping participating and non-participating. It really does require this company to really go out there and do their work. And it gives the power to the people, you know. If they don't want it in their neighborhood, then it stays out of their neighborhood.
Well, and I don't know about the things that we listened to in the first half an hour of this meeting about animals and feed on horses turning around or whatever it was. But, you know, that's an issue that it's not, you have to think about that. No, I think on our trip out to the wind farm, I didn't attend, but as I understand, those people didn't have any complaints about that kind of problem at all.
Well, let me just, you guys have lived here longer than I have, but I have actually driven through that area. And the area where in Hutchinson County, I don't think I got into Bonham County, but in Hutchinson County, where the wind turbines are is the rural equivalent of a ghost town. Virtually no one lives there anymore. You'll see plenty of farm places, but when you drive down the driveway, there's no house. Or if there is a house, it's a tumble-down shack. So the area we're talking about here in Yankton County has a lot of people living out there. And it was pointed out to us earlier that within a mile of these folks' house, there's several residents. So that was the whole reason, I think, that we decided to go with participating, non-participating. Because if the company wants to work hard enough, they might be able to get some people to participate. But it gives the landowner, resident, the option of saying no. And that's, to me, that's the American way of life. That's what we do here. We give individuals, we keep the rights with the individual unless they have to be overridden by the government. And one of the rights, you know, I'm talking now from my old real estate broker days, one of the rights of ownership is quiet enjoyment. That's in every deed. Quiet enjoyment of your property. And that's what we're talking about here. And that's what we potentially would be talking about taking away if we didn't have these setbacks. That's why participating, non-participating is the most important part of this. The 2 miles is great, but participating, non-participating keeps the rights where they belong, with the people.
Other thoughts on that? So far, the only change proposed is to increase the non-participating property line setback from 1 mile to 2 miles.
I echo Mike's comments. I think we're dealing with a 99.9 to the 0.1 situation. And in that regard, it is, I think, the most prudent path to err on the side of caution and property rights establishment. Should not be in the business here of emasculating property rights so the big boys can come through and do their thing. And I think that message has come through every night, every meeting we've had, everyone we talked to. We did hear from a gentleman who had a local job created, right? There are some things that should be considered. It's a couple of jobs, you know, in a pretty good economy. So, I mean, that's a real thing, small, but still tangible. So these things need to be weighed. And I think what we're hearing, and what everybody is pretty much hearing, is that they don't want them, and if they do want them, they need to have the ability to negotiate. So I don't think we should go down on any of this stuff. I think this is all solid, and it's moderate compared to what people are telling us. No, 5 and 10. So I think 2 is like, you know, the least we can do at this point.
Other thoughts? Okay. Mike, do you have thoughts, or are you good?
No, I'm good.
You're good?
That's-
Okay.
That's where we started.
I have one thing also that goes into this chart, and it's not included in this chart, and it's something that a lot of counties put into their ordinances, is pipelines, distance from pipelines. So a lot of counties have usually a height multiplier from pipelines. Similar to, and I think it's similar to what a right-of-way should be, a 1.5 from
Yeah.
pipelines.
Okay, and we do have one,
Add that in our
at
chart.
least one. Well,
At least
we've got
one.
gas lines too.
Gas lines, yes.
Okay, I can put that down there.
What setback would you have, Brian?
1.5 times total height.
Oh, good, yeah,
That'd be plenty
maybe
to
the
be out
same
of the
That makes
easement
Any
zone.
type of
that makes sense,
falling object.
yeah.
Yeah.
What about game production areas? I don't know that we need to put it in the setback chart, but it should at least be referred to. I think we talk here in item capital C about endangered species, wetlands, and migration. Might it not make sense to also say game production areas?
So who owns our game production areas?
State of South Dakota.
Okay, so that'd be the
And they get money
state.
from the federal government, and that's why you can't use lead shot, and that's the reason I know about it.
So can we, where it says residence, active church, business, schools, game production area, and include that?
That would be good, yeah.
A water tower?
Same thing with pipeline.
Well, then we have to, are we gonna start listing cell towers and the WAPA power lines and stuff? I mean, though, when they're citing those, they're not gonna put it right by a water tower. I mean, that's just asking for liability when the thing chucks a blade and things like that. And the water towers, where do we have one outside of a city?
Pearson's Corner?
Is it on Yankton side?
Yankton? It's 444 and 291. Right there in the middle of it.
It's like 2 miles north of Mayfield Store, isn't it?
It's 6 miles north of the Mayfield
6
Barn
miles.
Grove.
It's not a water tower, it's a water tank.
Yeah.
I mean, same difference,
It's a large BY water.
water tank.
Okay.
Use the water storage facility.
So what other things are we gonna have to list? I guess, you know, it's at a certain point,
Yeah.
you can't list everything.
Is there something that we could say, something of, that just kind of is the catch-all for these things,
Towers?
like utilities,
Utility infrastructure.
utility
1.5
infrastructure,
tower height.
that try to cover things that you just don't want the tower to, if something happens that you don't want them falling on them.
So I could put that in with pipelines
Yeah.
and
It'd
utility.
cover
Pipelines
pipelines
and
too,
utility
you know?
infrastructure.
Okay.
There you go.
There you go.
Okay, with,
Yeah, good,
ma'am, is that reasonable?
That is perfectly fine by me, thank you.
yeah.
Utility infrastructure. Okay.
How about floodplain? 1.5?
Well, you know, and that's just, what's the risk of putting it in a floodplain? So remember, we have to talk about risks. Like when we talked about hog barns in a floodplain, well, if it floods, the water goes in the pit and sewage can come out. Cell towers, do we allow cell towers in a floodplain?
We do.
We do. We allow power lines and things like that. So technically, you can build a home in a floodplain. You just you're paying flood insurance for it.
And I think, you know, we have rivers and streams, 1 mile. I think we have that pretty safely covered anyway with floodplains.
Correct. And the other, yeah, and to Ryan's point, our floodplains are all essentially east of the city of Yankton on the south side where it's low by the river and there's no wind there.
Let's just take it out.
So I don't think we
Take it
need
out.
to list floodplains, but certainly the pipelines utility infrastructure there's a benefit to it. Okay.
Gary, you got a floodplain map of the new floodplain?
It's a lot bigger
It's more
than it
than
used
just
to be.
southeast. It's more than just southeast.
Well, but it would be all along Beaver Creek because I have land along there and it's in the floodplain. But again, we have a mile setback from Beaver Creek.
We don't have that folder on this laptop, and I don't see a memory stick.
You know, so I think our mile setback from a stream would probably get most of our floodplain.
Yeah.
Yeah.
And Yankton County adopted for the state program for the discount in taxes, all the streams in the county are recognized as streams. So,
I think we had to walk up, you know, with turbines, the way they're built, we walked up 15 feet up them steps. So all their electrical is there at an elevated level. So it's gonna be a cable down, so it's not like, you know, the transformer's sitting on the ground.
okay. All right, so that circled back on our setbacks. At this point, we've got 15 minutes left. And I think the comment I made earlier about doing the definitions at the Planning Commission is probably, I don't think we need to go through definitions at this level. So are we wanting to meet one more time after this is all put together? Because the question's gonna be, we're going to vote, and who's in favor of advising the county commission to implement a ban? And then we have a vote, whether it's 5-4, 8-1, 09, whatever it is. But then we say, if the ban doesn't go through, if we're all for it, this is what we would do to mitigate the risk.
Yeah.
So, do we want to meet one more time?
I can do it right now.
Why, yeah, we can vote right now. My question is, do you want to meet one more time to go over any final language, or are we good with doing these updates, sending them out, and then everybody says, I'm okay with that?
I would suggest meeting one more time as, just as a, to be responsible,
Okay,
to be able to read in advance the final document that we are going to send forward to the planning commission,
all through.
and then come here and vote. I know it's you know, it's a sacrifice for a lot of people to come here at 4 in the afternoon, but
Yep.
still, I think it's due diligence to do that.
Big Brother sends out 20,000-page documents that they're supposed to sign.
Yes, we know that. We know that, and we don't want to be like them.
That's right.
Yeah.
Okay.
One last issue, Sherry, before we
Yep.
go any, before we finish up. Under large, I'm on page 3, section 2615, performance standards. We allow in commercial districts. I've looked at the map the best I can, and Gary can confirm for me, there just aren't very many commercial districts where this would work.
No.
So why do we include that in there? Why not leave it out?
It could change.
Well,
It
that's a
could
good
change.
point, it could change. Okay, I withdraw my objection.
Okay.
Okay.
So with that said, when we come next time, do you want to still meet at 4, or do you want to move it back to 5, because we'll probably have a short meeting? Or start at 4 and get done earlier?
I'd go with 4.
4?
4.
4 o'clock. So we'll meet 4 o'clock. We're gonna go over one final draft, omitting the definitions. Now, one thing I want to bring up before we meet next time is Mr. Welsh is going to be a member of our planning commission next time, because your first meeting is next Tuesday, correct?
Correct, and I'm gonna, yes.
Okay, so that means we have 4 planning commissioners next week, which is a quorum.
Ooh,
So, one of us has to bow out. And,
Put it in the paper.
well, you can put it in the paper, but we'll be voting on something
yeah.
as a planning commission without the other 3 knowing it. So I think one of us needs to bow out, and I can certainly volunteer if somebody wants to take the chair job next week.
No.
But, so,
Since I would
between
be
now
I would
and-
be the newest member, and
Yep.
it would make sense if I bow out of this meeting, because I'll be coming to the 7 o'clock meeting anyway.
And you're gonna be hearing all of this again as a planning commission member next.
Exactly, so
So,
I think it'd be
in
best if I bow
May.
out of the 4 o'clock meeting.
Okay, sounds good. I just didn't want to get us in trouble with
Should
that.
we do our vote while we have 100%?
We can do our ban vote now, though, so you can be on record with that.
Oh, good, all right.
Okay, so if I say, if you recommend that the county commission puts forth a ban, raise your hand, please. So 1, 2, 3, 4, 5, 6. 7. So 7 to 2. So I will make sure that that is reported. Actually, Gary, you could report that when it's presented to the county commission from the planning commission to do that. All right, with that, yes, you have not said a word all meeting, Lauren. Go ahead. Oh, here, let me shut mine off. Go
Okay.
ahead.
Now is it on? Okay. Now I forgot what I was going to, oh, I know what I was gonna say. So, with the planning and zoning, when we did the solar, you know, we got the red line with the process. Could we just, I'm distracted, but could we just get one that has just what we have now and not the red, you know, because that just confuses me, because it's like, well, this is what we had, and so if we could just get a clean, this is what we have currently, none of the other stuff before.
Yes.
No, Gary. Save the ink. Save the colored ink.
So what I envision happening is the entire Article 26, when we're presented, will be stricken.
Yep.
And we will have new language there with all the reorganization. And so you can read through the new language cleanly. But the old language will have to be stricken when we actually present it to the planning commission.
And just look going forward, so planning and zoning meets next Tuesday, so obviously we won't have it for that meeting. So we're looking at May then, to be put in front of the planning and zoning.
Yep.
One meeting,
I would think the first meeting, yeah, it needs to be sent out, everybody needs to have read it. You come and say, what are your concerns?
okay,
And if we see concerns that we need to further discuss, then it's going to take more time. If everybody says, you know what, this looks really good, then in June, we would have to have the formal
yep.
public hearing.
So the earliest,
One of the reasons for the task
You gotta
force,
decide if it's a hearing.
yep,
I would say the hearing would be the following month.
one of the reasons for the
Right, that's
task
right,
force
yep.
setup was to try to eliminate
yep.
and get consensus sooner.
So the earliest to the commission would be,
June.
July,
July.
okay?
July.
Just getting a time frame in my head.
So there has to be 2 meetings,
Yep,
and then 20 days in the newspaper.
yep. And then,
2
yeah.
weeks advertising and then 20 days.
Oh, gotcha,
yeah,
thank you, Gary.
yeah. And the other thing too, that just sitting here, and I guess the reason I'm so quiet, SB 201. I mean, we go through all this work, we're doing all this work and everything. If that sucker goes into effect, this is gone. It goes to the pier. You lose your local control. And so I just want to put that out there for everybody to chew on. If you haven't signed the petition, go for, do that, because, this is all this work, and I think of all the work we put into solar and all the work we put on here, and our legislative body has decided that we don't know what we're doing. Not everybody, thank you, yep, you're right. So, just want to put that out there, so.
Before you adjourn.
Hang on 1 second, I'm going to let Mike speak first. Go ahead.
I'm just gonna ask if Gary, when you send out the final here, as Lauren was asking, could you also send out the one that is green or whatever it is, and red and all that? So then if there were questions in our own mind, we address them right there. Right, if that isn't too much difficult. Thank you.
Okay, ma'am.
I just wanted to say, while you're all actually here, we've been here, we watched you, we know that you sacrificed to be here, we know you were thorough, and we really appreciate that you went out of your way to listen to the people that did come, and I know you put a lot of time into it, and you did a really great job, and I would thank you.
Thank you. Appreciate you guys all coming too, hanging with us. So with that, we're actually 5 minutes early. I'd entertain a motion to adjourn. Mike moves to adjourn. Do I have a second?
Second.
And Mike seconds. All in favor say aye.
Aye.
Aye. All opposed nay. Motion carries. We are adjourned. Thank you again.